Very safe.
We call the meeting to order. Hannah, would you please take roll call?
Mr. Nobles,
Here.
Ms. Flood,
Here.
now,
Here.
Mr. Tucker,
Here.
Mr. Vogel,
Here.
Mr. Golden,
Here.
Mr. Pollard.
Here.
I note that a quorum is present. We have Ms. Bud on the phone, who, this is a reminder, when you're on the phone, you're unable to vote on matters, so item number 2 is approval of the minutes of the meeting of October 22nd. Have a motion?
So moved.
Second. Any discussion? All in favor?
Aye.
Ms. Bennett, any agenda changes?
There are none.
Public request. If any member of the public wishes to provide a comment on any item, the time to do so is now. Please complete a public comment card identifying the item upon which you wish to be heard and provide it to Ms. Nevada. The public comment cards are located at the back of the room. Each member of the public wishing to comment will be provided with 5 minutes to do so. The chair reserves the right to move the public comment opportunity on a specific agenda item to the point in the agenda when that item is to be considered and or to extend the allotted time per speaker. Hannah, do we have any public requests?
There are none.
There are no items in the consent agenda this evening. Federal, state, and municipal input. Ms. Bennett, any input?
There is none.
Item 7, financial report. Mr. Now, would you please introduce?
Yes, sir. Thank you. You have before you in your package, the financial report for October 2025. It's the first month of our fiscal year, so it's very early to draw any kind of conclusions on anything. We do have some variances on the expense side, which Robert will go into. I did review the detailed accounts that underlie both this, our package, our board package, as well as the summary Robert will provide. So Robert, I'll turn it to you.
Yes, thank you, Mr. Knapp. So before you is the financial report through October 31st, 2025. Total operating revenues are 667,000, and that's up 1.3% budget year to date. Total operating expenses are 443,000. That's down about 31.9% budget year to date. And then total income for depreciation is about $223,000. And as Mr. Now said, there are some variances in the expenses, and these are to be expected during the first month, just due to timing of the invoices, especially in our projects and our marketing special events. So those variances there are just due to the timing of the invoices we've received. So with that, on behalf of Airport Management and Secretary Treasurer, respectfully present the October financial report.
Is there a motion to approve the October 2025 financial report? Mel? Second. Second, Bob. Any further discussion or questions? All in favor?
Aye.
Motion carries. Tenant reports. There are no tenant reports or requests for the month. Executive Director and staff reports. The operations and noise abatement report for the month of October. Lionel, you're going to present this.
Thank you, Mr. Chair. Good evening. For you is the noise. The noise report, the noise abatement report for the month of October 2025. In the month of October 2025, there were 8,782 operations, which is an 18% increase in the operation from October of 2024. In October, there was one VIP CFR, which make 11 the total of the CFR signs of presidential inauguration back in January 2025, and a total of 6,075 operations under these TFRs. The TFR that occurred in October, for that weekend, we have 388 operations, which is like a 77% increase compared to the same weekend of last year. And to summarize, the last TFR was in May. We didn't have any during the summer. Now we're seeing an increase of this TFR. GLA deliveries increased by 26% compared to October 2024, and ABGAF delivery decreased by 26% compared to October 2020. There was one household located on the northwest quadrant of Bible noise concern in October of 2025, which was from the online noise reporting. During the month of October 2025, Cousin have 80 aircraft clearings, which is a decrease from the 89 total clearings during October of 2024, and there was no vessel clearings. These 80 aircraft arrived from 20 different countries. There were 15 after-hour clearings the month. And our lovely exhibition area welcomed 986 visitors in October 2025. That concludes the operation report for the month of October 2025. I'm happy to answer any.
I would just like to say on the observation area, I was just out there and it looks fantastic. With the weed control and the nicely mowed lawns. So just in 1 month's time, yeah, it's been a drastic transformation. It looks beautiful. 2 little 2-year-olds were actually rolling down the hill. Yeah, they just been for it was so fun to watch. Anyway, great job.
Thank you.
Thank you, Bob. Anything else? Any other questions or comments? Okay, thank you. Airport flooding update. I'm sure if we've ever seen that as an agenda item before, but Travis?
And hopefully this will be my only one. Got a couple stats and a couple of videos and time lapses to show. On the evening of October 26th, the whole Boca area experienced basically a historic flooding event. Not dislike from what the FLL had a couple years ago, where one heavy thunderstorm just grew and didn't move for several hours. After being out and about on the streets that night and seeing cars floating through intersections closer to downtown, I decided to pop in here to check on things, and an abundance of safety at about 11:30 that night decided to cease operations due to the rising floodwaters. It was still coming down quite heavily, and we didn't really know when it was going to stop. Took some calculations around several areas in Boca, took between 7 and 9 inches that evening, which our friends here at Garver Engineering had run some numbers, and that's between a 500-year and a 1,000-year flood event. Meeting with the FAU utilities team the following morning, they said the rain gauge on their utility building between 10 p.m. and 2 a.m. took 13 inches. And that would be well above a 1,000-year flood event for this area. Thankfully, we didn't experience any building flooding. Everything stayed out of, it seems like all the tenant facilities as well, including ours. One of the videos we'll show here in just a sec did show from our customs ramp, it crept up almost to the back door. We had to clean up grass clippings and things from the ramp the next morning. So it was a steady lake from basically the edge lights at the edge of the runway all the way into the customs ramp, and driving down the taxiway in some areas was 5 to 6 inches deep. Pushing a wake off in the truck. So that was going to be unsafe to operate any, especially propeller driven aircraft that were lower to the ground. So, and thankfully, like I said, the runway remained, I won't say dry, but it's not submerged. But everything else around here kind of took a hit. I don't know if hopefully they'll work, but we'll see what we got here just to demonstrate. It's like this first view. Our air traffic control tower facing south, and that is a large factor. That access road is completely submerged, and it's on almost continuous lake from the edge of the runway in. We kind of sped through it till the following morning just to kind of give an idea. It had already receded some, but that's the next morning. We still have spots underwater on the access road, and someone from the construction company had to wait out to the tractor there, rescue it. The next view, I believe, would be, yeah, that's our customs ramp. You can see the swirls of water coming all the way. That's the innermost center line stripe for the parking area. So the door is roughly about 50 feet from that, give or take.
I got a couple photos after that to show driving down the taxiway. Unfortunately, I didn't have a lot of them because they came out rather blurry. I was a little wet. So the last one's just along Airport Road. This is at around the hotel area in our electrical vault. Just if you look at kind of, there's almost no water in the storm swale bottom, and within a period of a couple hours, it almost overtops the
Wow.
intersection there. And further south from the Boomer's property where we don't have as much coverage, Airport Road was fully inundated as well as Boomer's parking lot. The storm swale was one continuous. We were taking water from the interstate, and at the exit discharge structure on the south end of the property that goes behind FAU was completely over the head wall, and I believe probably about 6 to 8 inches up the fence. And unfortunately, it also kind of coincided with a high tide event in king tide season and 13 inches of rain, and there's just no place for it to move. I think there was a couple photos in there too, just to give. Yeah, that's driving down the access road. There should be some nice reflective brand new white stripes for the brand new pavement. That's roughly 6 inches deep. So I stopped and backed up because I wasn't really quite sure of what the water fording depth capability of an electric truck is. I didn't want to find out the hard way. So I just got one more, I think. Yeah, that's Taxiway Bravo, just before you get to the deep water in front of Customs, and right beyond that, if you can see, it's a little blurry, but the water made it about halfway up all the taxiway signage and completely inundated some of the lights. So which are roughly 8 inches high. I think that probably be it. Up there, sorry. There's the next morning after things have receded some, and but even at the very the end of the canal was still right at the very top of the end wall. So it's just still, there was still really not a lot of places for it to go. So I know driving through downtown, there was definitely people with floating cars. Thankfully, I drive something taller and was able to get through, but it was over the front bumper of my Jeep. Many intersections around town, and that was earlier than when it really started coming down. Hopefully, we don't need to have this presentation anytime soon again, but it's just, we, all things considered, we fared fairly well. We really didn't lose any equipment or property. So just wanted to give a quick little update on what it looked like out here that night.
Thank you, Travis. That was very eye-opening for sure. So, noise monitoring. Oh, sorry. Go ahead, Chief. Yeah.
Okay, thank you. Were there any problems in our new retention area at Atlantic?
No, thankfully, both of those structures that remained in place, and the fresh sod got watered nicely, but those appeared to function completely as designed.
Right.
Nothing was displaced, and they conveyed water just as they should. As you can kind of see, that's just a little south of where those are located. It is still conveying water at a fast rate south. So they were doing as designed, and they got, I guess, the ultimate test pretty quick after they got installed.
Very good.
Other questions for Travis? Thanks, Travis. Okay, item C, noise monitoring and flight tracking system and noise monitor service and maintenance. Robert Pratt.
Thank you, Mr. Chair. Good evening, Robert Pratt, Operations and Program Manager. The Airport Authority entered into an agreement with EnviroSuite in 2022 for aircraft noise and operations monitoring software, or ANOMS. This contract was for an initial 3-year base term with 2 1-year renewal options. The initial 3-year term expires on December 31st of this year, and we are seeking board approval to initiate the first 1-year renewal option. This renewal will be for services starting January 1st, 2026 through December 31st, 2026. So with that, Airport Management recommends approval of Resolution 113325, approving a 1-year renewal for ANOM services with the EnviroSuite.
I'll make a motion to approve. Second.
Any questions or comments? All in favor? Aye. So moved. Thanks, Robert. Contract award for EMAS repairs. Travis.
Thank you, Mr. Chair. The board remembers at the September meeting, we awarded a contract for the manufacture and delivery of the blocks themselves, as Runway Safe, is the loan manufacturer. We released a ITB and which closed on November 10th for, the install, the labor portion of the, repair. The sole bidder, has done work here, previously and installed and repaired, the beds. And are very qualified and work with, the manufacturer Runway Safe, frequently on areas around the country. And the one bid received, was $168,000, and Import Management recommends approval resolution number 113425 to Boland's LLC, for labor portion of the, repair.
Motion to approve this resolution.
So, second.
Discussion, question?
I have a question, when can they start? Because I know FAA is looking to have this done as quickly as possible. Was that in my report here or?
In talking, recently with the manufacturer, they expect to be able to deliver the product sometime around the first, week of December, so sometime shortly thereafter. So we're supposed to have a chat with them, into this week to trying to finalize when things might, be on site and when we can, send some notices out, very soon about, nightly closures for that.
Thank you.
And then we have to hire an installation company.
That's what we're doing right now.
So this is the.
Yeah.
Okay.
Yes, sir. This is the,
Catch up.
Yep.
Got it.
Any other questions or comments? Did we, get a motion in a second, right?
Yes, we did.
All in favor?
Aye.
Motion carries. Presentation of the final noise exposure map report. This is a follow-up to the extensive presentation we had last month. Robert?
So thank you, Mr. Chair. Won't be doing an actual presentation. This is more just to kind of recap what's been done since last month's board meeting. So as you will recall at last month's meeting, representation from Recondo and Associates provided an in-depth review of the draft NEM report that we will be submitting to FAA for their acceptance. As mentioned in that meeting, we were within a 30-day public review period where we were accepting comments from the public on the NEM report. The public, that public comment period ended on November 6th, and we received one comment which was included in the report as required by FAA. Although Part 150 does not require us to respond, I did respond to the gentleman, and his questions were mainly if the NEM update were going to affect flight paths over his home or if his home was going to be affected in any way. So aside from incorporating these comments into the report, there have been no other changes since last month's presentation. And so with that, Airport Management is seeking approval from the Airport Authority Board to submit the updated NEM to the FAA for their acceptance on behalf of the Boca Raton Airport Authority. And I do have John Williams from Recondo on the line if anyone has any additional technical questions from them. Yep.
First, is there a motion and a second? I'll second it. It's seconds, discussion, questions? I have one question, but go ahead, Jim.
My question is about public engagement. I know we sent out many notices in the neighborhoods and association. I didn't see a lot of names on the sign-up sheets that are included in this 300-page report, but so were we satisfied that we reached out to everybody? Do you take that as a positive that not meant that?
Yeah, we definitely met the requirements per Part 150 for, so, engaging with the public and notifying them. The Noise Technical Advisory Committee, we invited probably twice as many folks as what came to the first meeting. The first meeting had the biggest response with over 20 people. And then, the next two had a little less and less, unfortunately, after that. But the NTAC was a specific committee that we identified, which included, stakeholders, tenants, community members, HOAs. We had a good representation of all of those. City officials, assistant city manager was here. And then the public meetings, the public open houses and the board workshops, they were, the public open house was put in the Sun Sentinel both times. For that, we listed on all of our social media. It was on our website. And all of that material has been put together in that package, which will be submitted to FAA because FAA wants to see, what we did to make sure the public was aware. So.
Thank you.
Yes, sir.
And then is there a step beyond the FAA approval or is that the final step.
Yep, it's so they wouldn't be approving it, they would be accepting it. So basically they would be saying that they agree with the methodology that was used to assess the land use around the airport, and they agree with everything that was in the report, and they will accept that. And yes, sir, that will be the final step in the process.
And I'm guessing they don't adhere to any timeline.
Yeah, yeah. We've had really good engagement with them throughout the process. They are aware that we're doing this, and local representation from the FAA have participated in all of the NTAC meetings. So they know that we are going to be submitting it to them soon. But unfortunately, we can't guarantee a timeline of how long the process is going to take. Yep, for them.
Probably be extended because there's typically 3 environmental specialists that review things like this in the state of Florida. They've been down to 1 for about the last 6 to 8 months, so.
Yeah, as we discussed and when we had these meetings, when you get low turnout, that means you're doing things right.
Nobody's
The
questioning.
community will let you know, I've done this many times. If you're not doing it according to community needs, they will be out in force. So
Good point.
it showed that, we're really addressing everything, and this is the most complete report I've ever seen.
And to that point, Mr. Chair, the FAA had extensive input in the scoping of the project before we even engaged with the planning team to ensure that they were comfortable with the methodology for the public outreach in particular and the makeup of the committee. But to answer your question regarding the typical process, so we adhere to the requirements of Federal Aviation Regulations Part 150. A full Part 150 study typically involves 2 studies. It involves the development of the noise exposure map, which is what we did here, and a follow-up second part, which is a noise compatibility program. Typically, a noise compatibility program is done to reduce the size of the contours, to reduce the amount of presence of incompatible land uses within those contours. However, in this case, what we agreed as an organization is that we would initiate the first step of the Part 150 study, which is the noise exposure map update, to determine what levels of incompatibility exist around the airport. Because if you'll recall, it's based on the noise contour map that we generated in 2017, there were no areas of incompatibility within the federal threshold, the 65 DNL. So we completed this study with the promise, if you will, that if there were areas of incompatibility that were identified that would benefit from a noise compatibility program, then we would proceed with that second step in the process. But as you saw from the report, there are no areas of incompatibility that would meet the federal threshold. So we're comfortable that we don't need to proceed with a noise compatibility program because it would be nothing that eligible for FAA approval for that element of the program.
Excellent. Okay, we have a motion and a second. All in favor?
Aye.
Aye. Opposed? Motion carries. Amy is gonna, we obviously are, do a lot of our own required, ethics and sunshine law training, but, we thought it'd be a good idea for Amy kind of just to give a little overview of, things that we should be aware of, just for everybody's benefit. It never hurts to refresh on compliance, so, Amy.
Thank you, Chair, and good evening, board members. There are a lot of slides. I'm going to try and go through them quickly, but if there's something that you want to spend any time on, please let me know. The things that I'm going to try and talk about here today, we're going to talk about ethics, we're going to talk about sunshine law, we're going to talk about public records. I could spend quite a bit of time on each of these, and so this is intended to be high level review of these topics. We're starting with ethics. The ethics statute of principal concern for you is Chapter 112 Florida statutes. However, there are a variety of statutory provisions that bear on the behavior of public officers, and you can find that throughout the various volumes of Florida statutes. One good place to look if you're independent and curious and you don't have access to me, although I can reach me via email or telephone, whenever you need. is the Florida Commission on Ethics. They've got a great website and they have ethics opinions, both formal and informal, that are organized by topic. And so if you have a general interest in a particular subject, you can see decades worth of evaluation that the Florida Commission on Ethics have done in context. And so sometimes it helps because there's nothing new under the sun, and what you're experiencing, somebody else may have gone through, and that can be really helpful. So one of the principal things, obviously, that you're concerned with is going to be when and if a voting conflict is under Florida statute. You are obligated to vote if you are physically at a board meeting on all board matters that come up for a vote. While you're there, you cannot abstain, except when you have a voting conflict. And if you have a voting conflict, you must abstain. The law says you shall not vote on any measure which will adhere to your special private gain or loss, or the special private gain or loss of any principles. The definition of public officer is here on the screen, and obviously does apply to you. So the question is special private gain or loss. What does that mean? So the first thing that you need to think about is, does it apply to you, or does it apply to someone who's affiliated with you that you have to care about? And that would be a principal by whom you are retained. So in essence, the client. A parent organization or a subsidiary organization that is yours, relatives, and there are defined relatives in the statute, they're listed here, or the business associate. If it is the special private gain or loss of any people who fall in those categories, then you are required to abstain from that vote because you are conflicted. So and this is a really important thing. I think that a lot of people get confusion about special private gain or loss. There are a ton of different ways that you may feel benefited by something, but the focus in the statute is on economic gain. And so it's really about whether or not you are seeing that financial gain rather than something that you really care about that, is important to you. Deciding whether or not a gain is a special private gain or loss it requires consideration of a number of factors. And, the most important one is, are you affected in a way that's different than another person on average? And so the class of people that's affected by the vote, the degree to which the interest is affected, the nature of the interest, and the degree that it affects you versus other people, those are all things to consider. A couple of examples of how that has shaken out. These are Florida Commission ethics opinions. In one instance, there was a commissioner who was prohibited on voting regarding the acquisition of a parcel owned by his brother-in-law. That's a direct economic interest to a defined person. By contrast, the mayor of a town could vote on de-annexation, even though it affected the subdivision where that mayor lived, because it was affecting everybody in that subdivision and not just the mayor, even though de-annexation had an impact on that person's residence. So that's an example of kind of scope and nature. Other considerations in addition to, are you a member of a sufficiently narrow class, is how speculative or likely the gain or loss is. If it's something that might lead to something that might lead to something, you're less likely to have a special private gain or loss under the rule. And are you, the second one is the measure procedural or preliminary? If you're not voting on the ultimate decision, but you're making preliminary rulings, then that has an impact on whether or not this specific vote is considered to have caused you a special private gain or loss. So these are some things to think about. I will say, if you know something is coming before you as a board member and you're not sure where you fall, in addition to the resources on the Commission of Ethics, you can reach out to me, and I have, as your lawyer, issued opinions on that subject, and I'm available to do that, both to give you confidence on how to proceed, and it's also protective of you that you have done your due diligence and asked the question in advance. So if you have a conflict, what do you do? Number one, you abstain from voting. That's what the statute requires. Number two, you have to disclose the conflict prior to the vote so people understand why you are not voting. And then number three, there is a form that must be filled out and kept with the person responsible for keeping voting records, which is the person who functions as your clerk. Okay, some last notes that I think are important for you to keep in mind is your obligation not to vote on a conflict is different and apart from your obligations under other parts of the ethics law. So for example, there are certain prohibited business relationships that the ethics chapter governs. Not voting on things doesn't mean that you fixed your prohibited business relationship, for example. And so I don't want for people to get confused that it's a cure-all to not vote on something. You have other obligations as well. If something happens during a meeting and you become aware of a conflict, make the disclosure immediately and then file that disclosure form within 15 days. That's the way to handle that if it's not apparent to you from the agenda that you are going to have a voting. Okay, yes. So, and I will tell you in full candor, this PowerPoint is patterned after something given to a broader audience where it is important to distinguish between bribes versus gifts. I personally don't feel like I need to distinguish that for you. So I want to make clear that this is kind of a standard slide. But a bribe is either a direct or an implicit quid pro quo. Just because something is not a bribe doesn't mean that it is acceptable to accept it. The gift law goes beyond prohibiting quid pro quos, which are obviously bribes. A gift is obviously anything of value that is accepted by the person or on the person's behalf that benefits that person and for which consideration is not. Things that are gifts, obviously. Gifts can be monetary, they can be physical, they can also be acts of service that have a monetary value in the marketplace. They can be, preferential rates or terms, discounts, and then they can be things that, you're more commonly expecting them to be dues, fees, tickets, use of property, things of that sort. Things that are not gifts, your salary, if you are practically employed. Campaign contributions that otherwise meet the finance laws, honorariums, plaques. I'm sure all of you have gotten your fill of plaques from time to time. Those are not gifts. Things from your relatives, those are not gifts as well. So in consideration of the gift law, it's important to understand who a lobbyist is because the law puts special requirements on lobbyists. Lobbyists have to disclose when they give gifts to local officials. And so on the screen, you will see that a lobbyist is any person who within the past 12 months for compensation seeks or has sought to influence your decision-making or seeks or to encourage passage, defeat, modification of any proposal or recommendation. What's important there is the lobbyist is doing it for compensation. So people who are interested in what comes before you, but are not paid, are not lobbyists for the purpose of the way that 112 defines lobbyists. This again is more of the generic slide saying that ignorance is no excuse, the burden is on you, and that the ban that applies to gift law applies both to you, your spouses, and your minor children. So what is the rule with respect to gifts? You can accept gifts under certain limitations. You can take gifts from lobbyists, their principal, or a vendor, as long as it's valued less than $100. You can accept gifts from political committees with that same limitation. If it's over $100, you can accept it on behalf of your agency, but you have to transfer the directly to the agency when it's received. And then gifts from your mom can accept relative gifts, as I said, as long as if she's not a lobbyist. Okay, so disclosing gifts. If you receive a gift from a lobbyist under $100, you know, the political, campaign, all of that was on the previous slide, you may accept it, but you have to fill out a form. It's important to note that the lobbyist separately has an obligation to fill out a form, and so if you don't fill out yours and they fill out theirs, that might cause you some problems. So just be aware that they will be disclosing it if they're on the up and up, and, you know, lobbyists who do this for a living, I would say by and large, they follow the law because they know better than not to. Some gifts, the face value of it is not all that easy to figure out. And so how do you do that? Well, you have to think about the general market value. Or if multiple values exist, you have to choose the one that is the greatest. So, you know, if it's something that, you know, you could determine the value in a few different ways, pick the one that is the largest and use that one. Lodging in a private residence, there's a statutory number of $44 a night. For private transportation, you're just relating it, I don't know why that is. You are relating it to comparable commercial conveyance, and then tickets are at face value.
They're obviously not staying at the Fogels. That's a cup of coffee. Yeah.
Okay, so, we've talked about that, and we've talked about gifts. The third one that, I think causes the most questions is the notion of permissible or prohibited business relationship with your own agency. You are not allowed to, do business on behalf of your agency with an entity, where you, your spouse, your child is an officer, partner, or proprietor, or you have material interest of 5% or greater. And you cannot be employed by or have a contracting relationship with the entity that does business with your agency. And so those are the prohibited business relationships. This is a separate requirement that you cannot misuse your public position. I think we've probably all seen on social media people who get pulled over by the police and do you know who I am kind of situations. And so it's worth understanding that you cannot attempt to leverage your official position to secure a special privilege or benefit for yourself or for others. Seeking to use the equipment or the property of other government agencies for your own personal use. There are a variety of ways that people get themselves in trouble under this one. It's worth acknowledging. Disclosure of information. Officials and employees cannot make use of information not generally available to the public for their personal gain or benefit. It's kind of the informational equivalent, I guess, of insider trading. However, this requirement should be considered in the backdrop of our extremely liberal public records law. And so most of what you deal with is going to be public record and is not generally available to the public. And so that's really the critical piece of, I think, of this admonition. Nepotism, public officials are precluded from appointing, employing, promoting, advancing, or advocating a relative. If there's an exception for municipalities under 35,000 people, not relevant to you, but that's the statutory limitation. I know that here in Palm Beach County with our Inspector General, people want to know how those local requirements apply to you. And so it's important to know that Chapter 112 expressly allows for localities to have stricter ethics standards. Palm Beach County does have a county commission on ethics, and they have created an Inspector General position. The Commission on Ethics of the Inspector General applies to you only if you opt in. There was litigation early after the ordinance was adopted that confirmed that this is an opt-in relationship. And as of this date, the authority has not opted in. So, and then this is the reference to the Inspector General. Okay. So part 2 is about the sunshine law. Before I leave off on ethics, does anybody have any questions? You are all old. Okay, so people talk about sunshine and public records, sometimes they mix up the two concepts. The Open Meetings Act, which is chapter 286, governs what we generally refer to as the sunshine law, the open meetings law. And that has to do with when you as a board can communicate or take action on official business. The public records law has to do with written material. And that's typically found in chapter 119, and we'll talk about that next. The general obligations of chapter 286 is that when you interact with each other on items that are official business of your agency, that your meetings must be open to the public, they must be subject to reasonable notice requirements, and you must take minutes of what happens at your meetings. The first question really has to do with what meetings are covered, and that's always, the place where it can get a little confusing. You're a collegial body. There are a variety of you act only in your corporate capacity when you vote with each other. Therefore, any meeting between any of you is an open meeting. Is a meeting that's subject to the open meeting requirements when the subject matter that you're talking about is something that is likely to come before you for action. So that's what's governed by chapter 286. There are rare exceptions to the obligations under chapter 286, and they have to be set forth in Florida statutes. So there's no such thing as like a common law exception to the open meetings requirement. And it's important to understand that meeting doesn't necessarily mean physical face-to-face. You can be conducting a meeting by talking to each other on the phone, through email correspondence, written correspondence, and social media, and by using staff as a conduit for communication. All of that behavior is subject to the open meeting requirement. So one of the questions that happens a lot is, okay, so that you guys are covered by the Open Meetings Act. What about people who advise you or that you task with giving information? That can be procurement panels that you convene to help you make a decision on a contract. It could be a hiring committee that somebody might have put together. There's a variety of settings where sunshine boards will convene an ad hoc committee to do some work on their behalf. And the distinction between the two is fact-finding ad hoc committees are not subject to the sunshine law, but advisory committees are. And so if someone is giving you advice, giving you recommendations on how to behave, they must meet the sunshine law just like you have to meet the sunshine law. And so that is, you'll see here on the left, advisory boards, the distinction between decision-making authority versus fact-finding. When you're talking about staff meetings with each other are not typically sunshine because they're not board members, which makes sense. Staff meeting with you as individuals are not sunshine meetings because they do not involve more than one person on a collegial body. The only thing to keep in mind is that you cannot give staff decision-making authority that would otherwise belong to the board, because then you can convert them into sunshine agencies, as we were talking about, like ad hoc committees, and you cannot use them as conduits to communicate between each other indirectly. Those both violate the sunshine law. Okay. Other meetings, it is not infrequent that because you're all civic minded that you may serve on multiple boards together, where you may find yourself at meetings where one of you is at bias and the you is in the audience. Those situations in and of themselves do not violate the sunshine law. You simply cannot talk to each other about things that are likely to come before you in this setting about this agency when you find yourselves out in the wild, if you will.
Amy, just a question on that. So, like, if Mitch and I end up at the Federation of Boca homeowners meeting, and Gene is also there, and the subject of noise from the airport comes up. Like, which is, you know, a topic that we often talk about, is, you know, how do you avoid situations like that, or is that not a violation?
If what you're talking about is something that's likely to come before you, so for example, if somebody in the meeting says, wow, noise is a problem, are you guys going to take any action on it? And then you commence the conversation about different things you could do to fix that, that would be a violation of the Open Meetings Act. And I would encourage you, you know, discretion is the better part of valor in this scenario. If somebody brings up something about the airport and you're all together, I would recommend that you say, you know, we have obligations under the Open Meetings Act, and I don't want to begin a discussion that might lead us in the direction of talking about things that might come before you. But the specific provision that you would be violating is only when you're talking about something that is likely to come before you for a vote. That's where the demarcation is. Many of you, I'm sure, have heard the word shade session or executive session. And so sometimes it's helpful to understand the limitations. There is a litigation exception where you can meet in private with your attorney. And the requirements of that are fairly narrow. You can do that when you have advice that's needed on litigation strategy or settlement negotiations. It has to be specific to the cost of litigation or the litigation strategy. What happens commonly is people will be in a lawsuit. They want to talk in the context of a shade session about, you know, things that have come up during that lawsuit that are not specific to how do I settle this case? How much is this case costing me? And that's really where you need to limit your conversation, because if you go into, well, you know, if we do this, then this person will go away, but then this that you're talking about is not specific to settling the case, you will violate the limited coverage that you have under the litigation exception in 286. 011-8. So it's very important to keep those conversations narrow.
So we've been through that, right?
Yes.
So.
Yes.
Yeah.
It's important to know that the session is recorded by a court reporter. I have been in executive sessions, not with this client, of course, but in other settings where people felt very free with their words. Minutes being taken down, and eventually that transcript will become a public record. So you are, you know, you're on a hot mic, as it were. These are meetings that must be publicly noticed, and as I said, the transcript becomes public record at the conclusion of the litigation. So often people will ask whether you can have a shade session about something that you think may become a litigation in the future, but you don't have a pending case. The shade session is specific to pending litigation. But pending litigation does cover adversarial hearings, such as a DOA case. It's not just state or federal courts, so that's as well. All right, so transitioning from the question of what meetings are covered to now the second requirement, which is that you give reasonable notice. What are the requirements for that? Chapter 189 tells you what your notice requirements are. You have to file a schedule of your meeting, your regular meetings with your local general government. You need 7 days notice for special meetings that are not considered emergency meetings. And then for emergency meetings, you must give reasonable notice, which is not a defined term. But we can have a conversation, I think, on the next slide about the factors that lead into that. A couple of things that are important to know: emergency meetings cannot be the place where you approve an annual budget. And if you take action at an emergency meeting, you have to ratify it at your next general meeting. In terms of figuring out when reasonable notice, particularly in the context of an emergency meeting has happened, notice has to include the time and the place of the meeting. It's got to be prominently displayed in an area for that purpose. It should be at least 7 days unless there's an emergency. 72 hours notice is the general limitation for that kind of emergency meeting notice. And there are a variety of ways to get the word out. There's a list of them that has been identified in the Government and the Sunshine Manual as useful ways to disseminate your notice.
I mean, this is more pertinent really to staff than it is to board, correct?
It is, you know, it's good for you to know the general parameters, but your staff does a good job of working with council to make sure that these are all things that are. Again, things that you include in the notice, a lot of times people will ask, do you have to have, you know, specifics of a agenda or backup, things like that? You have to include those things if they're available. And so it's not a requirement if you're not able to provide it, and you are not limited to discussing only the matters that are on a published agenda as a function of the sunshine law. So that's an important to know. Let's see. Again, I'm not going to go through all of this in detail. These are notice guidelines as well about how you publish your notice. And this is the same.
Debbie Spector.
Okay, so then the final thing is
Cheryl, I'm on a conference call at a board meeting right now. I'll call you later.
so the final thing is your meeting minutes. Minutes are not the same thing as a transcript. There's something. Tape or audio recordings are allowed, but they cannot serve as your minutes. And many times I've seen them when they're corrupted, and so that's why the law requires you to have them in writing. 286.11.2 requires them to be promptly recorded, and so that's a very important time and consideration with how quickly you develop your minutes. You guys do a good job with that, but I've seen other districts get in trouble because there's a significant delay in minutes. You can send draft minutes to board members for review, but the approval of the board minutes has to happen in an open meeting. And minutes are public records as soon as they're prepared, even if they haven't been officially approved. Public participation is always an interesting thing in terms of the public records and the open meetings requirements. Members of the public have to be given a reasonable opportunity to be heard on a proposition that is being voted on. But that does not limit your ability to control the quorum. So what happens if you violate the Open Meetings Act? An important one is that the action you took at that meeting, the one that didn't comply with the sunshine law, is void ab initio, which means it's as though it never happened. You can effect a cure if you have an entire reconsideration in a public meeting. There are criminal penalties for knowing violations of the sunshine law. There's the threat of removal from office. There's non-criminal penalties, there's attorney's fees, and there's civil action. So it's a significant risk both to the business of the agency and to yourself personally if you knowingly violate. All right, public records law. So as I said, chapter 119 is where most of the public records requirements are located. A public record is any material that fits the definition, and so that can be anything both physical, electronic, audio, calendar invites. It's a broad category. And the significance of it is that it's a material that is made or received pursuant to law or ordinance or in connection with the transaction of official business. And it's something that's used to perpetuate, communicate, or formalize knowledge. And so that yellow language is really the key. That you ask yourself, does it fit those two requirements? And then the answer is yes, it's a public It doesn't matter what device it's made on, using your personal phone or a tablet doesn't make it not public record. So it's the content that matters, not the device. Social media posts can be public record and people have gotten in trouble for not retaining them and not producing them on request. Drafts and notes. If it's intended to memorialize or communicate, preserve public knowledge related to your official business, it's a public record, even if it's never, turned into a formal product. But personal notes that are designed for your own use are not producible. The classic case about personal notes related to, I think it was a city attorney, and it was the notes that the person had written down to prepare for an opening argument. They said that was just to keep that person's memory fresh, and that wasn't a public record. But often people will say, well, it's a draft or it's my notes. That doesn't mean it's not a public record. When you are asked for public records, it doesn't matter why the person is asking, and it doesn't matter what they're asking for. The law thinks that because you can charge for a service fee, that it doesn't matter how broad the request is. You can't object to it in essence. You can't require requests to be in writing. You can't require the person to identify themselves. However, you do not have to respond to a standing request. Someone cannot come in and say, I want you to send me every fill in the blank of a category of record. They have to ask for it in real time. Now, you may offer that courtesy to somebody, but you're not obligated to under law. You do not have to explain your records. You do not have to reformat your records or create records that do not otherwise exist. You have to produce your records in a timely fashion. What that means, what a reasonable time to produce means, is not a hard and fast rule under 119. The question is it a reasonable amount of time for you to retrieve the record and to review for exemption, privilege, and for redaction? There are certain charges that you're allowed to charge that is probably of more interest to staff. And I think it's important to note that if you say, okay, well, I want to withhold this on the grounds of litigation, work product privilege, that you need to identify what litigation it is that you are referring to. And if it's anticipated litigation, you need to identify who the parties are to that litigation and generally what that litigation is about. 119.12 is of relatively recent vintage, and it creates a 5-day notice before someone sues you on a public records law violation. They have to send you a letter telling you, I think that you're in violation and you have 5 days to cure it. If they don't give you the 5-day pre-suit notice, then you're not on the hook for fees anymore. So that's something that's happened within the last several years. Chapter 2021-173 of the laws of Florida has gotten rid of, there used to be the ability of a public records agency, if they received a public records request and they were not sure what their rights were, they could go to the court and file a declaratory judgment rather than comply with the public records request, and the court could tell them what their obligations were. 2021-173 does not allow for those hearings to be considered compliance with the public records law. You have to do your best to comply, and risk getting it wrong is how the law now reads. Okay. So this is explaining how you need to publish who your records custodian is, or how somebody can ask for records. It's important to make it clear to a requesting person, and it is on your website, so you are in compliance with that. There are retention requirements, obviously, that apply. The Department of State puts out a book of categories, and for each category of record, it tells you how long you have to keep it. So for some things, as soon as its administrative value is lost, you can get rid of it. Other things you have to keep forever. It depends on the content of the record. For your private contractors, there are times when your private contractors will either possess or create public records on your behalf. And 119.0701 explains the process if somebody wants to receive public records from your private contractors. This is a requirement that must be in all of your contracts, that's on the screen here, that just identifies that process. When you have a vendor and the vendor leaves, the vendor is obligated to provide to you at no cost all the public records that they have in their possession, because that material belongs to you as a matter of law. And they have to give it to you in the format that you ask for. If you don't specify, then in the format it's ordinarily kept. Okay. I've placed here a couple of things that I think are likely to come up for you specifically as an agency. It's important to note that for exemptions, they have to be exemptions that you find in state statute, and those exemptions are going to be strictly construed. So if you don't have a very clear reason to withhold, you should not withhold. Financial statements of prospective bidders are exempt from public records law, and there is a temporary exemption for sealed bids. And so they're not subject to the public records law until there's a notice of the decision, or until 30 days after the bid is open. So work product is the one that most people are most likely to wonder about. Under 119.0711D, there is a limited attorney work product privilege for public records. There is no attorney-client privilege in public records. So the fact that an attorney was involved in the communication does not privilege the document. The document is temporarily privileged if it otherwise fits this category until the litigation is over, and then it becomes a public record. And the work product privilege requires it to be prepared by the attorney or at the attorney's direction, exclusively for the purpose of litigation, and it must reflect the mental impression or litigation strategy, legal theory, conclusion of the attorney. So the litigation privilege is fairly narrow, and it's temporary. And that's it. I'm sorry to run through it so fast. There was a lot of material. Do you have any questions? As always, I'm here and available if something specific comes up.
Very often.
This may not fit directly, but should we be aware now that we're carrying official, airport authority tablet, should we be aware of any usage of these that may be compliance related?
So I will tell, as I said before, where a document lives is not dispositive of whether or not it is a public record. It's the content. And so there was a case involving the city of Clearwater where a newspaper asked for records that were on a city device, and they included very personal things of the employees, because the employee was doing personal stuff on their computer. That was what the newspaper was interested in, was the personal stuff. But the court said you can't get to it through a public records request, because just because it's on a public device doesn't make it a public record. It's really the content of the record that controls. That said, I will tell you that good electronic document hygiene is a very good idea, because if somebody sues over something, they have a right in the statute to an in-camera review of the material by the judge. And you don't want to be in a situation where a forensic expert is given your device for them to mine for information. That's an uncomfortable place for people to be.
What about, Mel wants to play Minecraft on it? Oh, personal use.
No, I mean, and I think that was part of what came up in that.
You can do that?
Yeah.
You should hear.
Well, I think that was part of what came up in that case, is they were trying to work the angle of this was an employee productivity issue.
Oh, okay.
They were using the public
Okay.
asset for private purposes. The question is, does the document memorialize, perpetuate, or communicate official material? And that was what the court focused on. But, you know, I think it's up for people who rely heavily on electronic, you know, tablets and phones. It is a good idea to have a work version and a personal version, because, you know, I've had clients who were like, I have pictures of my children on this.
They keep it simple,
So, you know, and
use
just,
it for this and I mean, we all have plenty of personal stuff, so.
And with regard to the iPad for us, and to have you use them is to ensure that, one, we have an efficient means of getting the information, because as you see, sometimes the agenda changes or there may be updates to the materials, and doing it in the hard copy just makes it more cumbersome. But also ensuring that the access to our network is secure, and that any information that we're giving to you through these devices is as secure as possible.
Okay, thank you,
very
Amy.
much.
Okay. Authority board member requests and reports. Does any board member have anything they would like to discuss?
Oh, sure. So our next meeting is December 17th. 5 o'clock, that'll give away. So, we can not have that meeting if I'm really, we can have the cancellation, or we can be earlier today if anybody has events that evening, which may be likely because it is that special time of year. Throwing that out there for all my brothers and one sister.
So I think the request, we can't cancel the meeting yet.
Correct.
But if we don't have a meeting, doesn't matter, but if we do have a meeting, that the request would be to move it to the afternoon.
David, we've done that in the
And we've
past.
done that in the past, and
Yeah.
I mean, I'm fine with it, anybody has.
I'm thinking like 2 o'clock.
12, 1, 2, we can bring payables, do it at 10 o'clock.
Do it at lunch?
No,
I don't lunch.
Yeah, I can do
We'll
it much-
confirm that Ms. Patrick's not available that day, so we'll have Janice.
Okay.
We'll confirm, Rustin, thank you. We'll confirm that she is available. So you're suggesting,
Let's do lunch.
Noon?
okay, holiday luncheon.
Oh.
Hello, Mr. Chair.
Yes, Cheryl.
I just wanted to make one comment before we close. You all may or may not know that our esteemed CEO is being considered for Women Volunteer of the Year this Friday by the Junior League. That's a very prestigious nomination, and we certainly wish her the best of luck. Friday.
Thank you, Cheryl.
Yeah.
This is clearly the year of Clara.
December 17th at noon.
The next year.
Thank
So just, so we will, if it works with Janice to, substitute for Amy, we will, plan on the meeting being December 17th at noon.
And we will
If
provide
we have a
lunch.
meeting.
I think we'll provide lunch anyway, how's
Okay.
that?
As long as as long as it's, you know, not more than what, $25?
Well, for lunch, I think we could go 100, right?
Oh.
You're 100.
Yeah, forget about the sandwiches, so, any other, board member discussions? If not, Hannah, is there any, public comment?
There,
Is there any other business to come before the board?
Just a quick question regarding these. So I did not get a chance to do anything for this yet. I see some people have cases already. Maybe some of you guys also got covers for your devices, like the
Protectors?
Yeah, I know you have enough.
Yeah, I'm brand new too.
So having said that, any recommendations from any of you?
Well, what we're gonna do is, we didn't want to pre-purchase cases because I know there are some preferences and, you know, personal.
For those of you who don't use an iPad, I would highly recommend If you get
Oh,
these
with the
with the keyboard.
Yeah, I think you have it one.
Yeah.
I have that one, my personal.
Yeah.
Yes, so if you just let Ms. Nevada know what your preference is,
Oh, okay.
you can get you one.
That easy. Thank you, Anna.
So, the next meeting is scheduled for December 17th, 2025, time to be finalized. But
Good.
it will be at noon. We gotta confirm that
Janice.
Janice can make it.
Hello, Steve.
We stand adjourned. Thank you.
Good meeting you.